Welcome to Laws 794, Tort Law in Commercial Contexts. What we're going to do in this course is we're going to begin with a problem, and we're going to follow this problem through various areas of the law. Okay, what's the problem? The problem is probably the biggest problem facing tort law. It revealed itself roughly halfway through the 20th century, a little bit later, so in the 1970s, and just got bigger and bigger and bigger and bigger, and is still very much with us today, particularly in this jurisdiction where the courts are still very much struggling with this problem and I don't think anybody thinks they've come close to an adequate solution. So what is this problem? The problem basically is the problem of economic loss in the law of negligence. Now I'm going to talk more about what that problem is in the modules, but let me just give you the basic problem now. The problem is this: we have a bunch of principles for determining liability in the law of negligence, and when you studied a tort law in part 2, you would have examined those principles, so you know that there's a standard of care, there's a duty of care, there's remoteness, there's factual causation, there are defences, and so you know all of this stuff. Okay, and the thing is that those principles seem perfectly adequate for dealing with the majority of cases, for dealing with cases where the plaintiff's injury is a personal injury. Of course, that's statute barred in New Zealand, but nevertheless, where the plaintiff's injury is a personal injury, it's no problem, or where the plaintiff suffers property damage. Okay, there's no problem there. The law seems to work quite well. But what about cases where the plaintiff suffers no personal injury or property damage, but suffers instead economic loss? Now, the worry is, the view of many people in this area is that if we imposed liability on defendants in accordance with the ordinary principles of the law of negligence, what we would get is a liability regime that was completely out of control. To use the jargon, we would have indeterminate liability. And we can't have that. We can't have indeterminate liability. We can't have a liability regime that's out of control. So what the courts do is, instead of allowing this, they impose arbitrary restrictions on recovery. In other words, they just come up with new rules based on policy arguments that restrict the ability of plaintiffs to recover for economic loss. Okay, now, what's the problem with that, you might ask? The problem is that because these restrictions are arbitrary, there is constant pressure on those restrictions to be changed, because the whole point of them being, the whole significance of them being arbitrary is they cannot be justified in a principled way. That's what it means for them to be arbitrary. So there's this constant pressure on them to change. So the courts are trying to draw a line between liability and no liability, but that line is never settled. It's constantly moving, it's constantly under attack, it's constantly being challenged. Now, what we're going to see is that courts in other parts of the world have recently adopted a new approach to solving this problem. They basically argue that the problem was all based on a mistake. It's all based on a misunderstanding of the law of negligence. And if we go back to first principles, if we go back to our basic understanding of the law of negligence, we'll see that this problem goes away. And that the courts have done this on the basis of academic work that's been produced by people that were read, including me. But the New Zealand courts haven't done this, and it's not really in their nature to do it for reasons that we'll see. So this is what we're going to start exploring. We're going to start exploring this problem and the way in which courts have tried and failed to solve the problem. We're going to look at academic writing in this area that has been very influential on the courts, and then we're going to look at how the more recent courts have tried to deal with the problem. Okay, and then we're going to take this idea and move it into other parts of the law. So we're going to look at a particular kind of situation that causes economic loss. That's what we call negligent misrepresentation or negligent misstatement, and see what the courts have said about that and see how that problem might be solved. And then we're going to find that this problem relates to other areas of the law as well as the law of tort. So we're going to see that it's not just the law of tort that's involved here, but in fact one of the issues that we're struggling with, that we're trying to deal with, is what is the connection between tort and contract? What is the relationship between tort and contract law in this regard? And we're going to look at that as well. And then if we have time, which we may well not do, but we'll see, we're going to look at some specific economic torts that deal with these issues. So that's just a general introduction to the kind of thing that we're going to be looking at in this course.